It's my pleasure to welcome you tonight to this discussion on the amendment of the rules of professional conduct by Nigeria's Attorney General and Minister of Justice, Abubakar Malami son. On 13th September, a gazette was released to the public announcing that the Attorney General had amended that by the power conferred on him by Section 12(4) of the Legal Practitioners Act, the Attorney General of the Federation has amended the rules of professional conduct for legal practitioners 2007 by deleting rules 9, 10, 11, 12, and 13. Once the announcement was made, the president of the Nigeria Bar Association released a statement saying that such action is uncalled for. So tonight we have eminent legal practitioners to discuss the subject. Dr. Rapulu Nduka is also with us now, and also Inibehe Effiong is with us. If Mr. Edun is not yet able to speak, if we can call on Rapulu, are you able to share with us your thoughts on that gazette released by the Attorney General of the Federation? So what do you think about that gazette released by the Attorney General of the Federation?
Good evening. Thank you for having me. Well, it's been in the news that the RPC was amended, and like every other person, every other lawyer, we woke up that morning and saw the gazette. We saw the gazette like every other person, and we know, and I think the major contention that we all have is that the amendment did not follow the normal procedure. The powers to amend is vested on the Bar Counsel, the General Bar Counsel, and but from what we can see, it seems as if the reports that we also had, the Bar Counsel never met.
The internet connection is unstable.
Okay, so can you hear me?
Yes, I'm hearing you.
Okay, so the Bar Counsel never met to deliberate on any amendments. The good thing is that we have NBA has some members representing the NBA in the Bar Counsel. And from what the reports that we got, there was no notice of any meeting. There was no deliberation on any amendment. And just like that, we also saw portions of the RPC being deleted and also being gazetted. So, and that's where we actually have a problem with that. And that's actually a major quarrel, because we believe that if something like that should happen, something that would affect the profession, then the normal procedure should be followed. We are all lawyers, and we are meant to abide or work within the dictates of the law. So that's what I would say on that for now.
Inibehe Effiong, please, can you hear me? Sorry, I think I muted myself. Are you able to speak now?
Can you hear? Yes, please.
Yeah, go ahead.
Now, I received the report of the purported amendment to the rules of professional conduct with other amendments, just like our National Publicity Secretary has stated. We woke up to report in the media and online that Mr. Abubakar Malami had altered the rules of professional conduct for legal practitioners in Nigeria 2007. And because of how controversial the aspects of the rule that he claimed he had amended are, lawyers began to interrogate the legality of the purported amendment. Facts emerged that clearly contrary and in flagrant violation of the Legal Practitioners Act, specifically Section 12. the Attorney General of the Federation, Mr. Abubakar Malami, claimed that he had amended the rules for lawyers in this country, which power it does not have, which power is exclusively vested in the General Counsel of the Bar under the Legal Practitioners Act. For me, as a lawyer and as a Nigerian, I find this utterly and unreservedly preposterous. To begin with, the document that we are talking about is the rules of professional conduct, the code of ethics, the moral authority for lawyers and legal practitioners in this country, in Nigeria. So when the Chief Law Officer, Mr. Malami, when the Attorney General, who has been made the Chief Law Officer of the Federation by the combined effect of Section 150 and Section 174 of the Constitution, purports to exercise power that to his knowledge, and even if he does not know, the law is that ignorance of the law is not an excuse. Power that is vested exclusively in the General Counsel of the Bar. I find that an indictment on the legal profession. I find that an unprovoked assault on the legal profession. I find that an insult on lawyers in this country. For the Attorney General, the man who took an oath as a senior advocate of Nigeria and as the Minister of Justice to uphold the Constitution and the law, to so publicly and blatantly violate the law and the rules of ethics that regulate the conduct of lawyers in this country. As far as I am concerned, this conduct, this shameful act, is sufficient to strip Mr. Malami of a senior advocate, but that is not even enough. To my mind, what Mr. Malami has done is sufficient for his name to be struck off from the role of legal practitioners in this country, and that is my position. What Mr. Malami has done is terrible, and lawyers in this country should stop sounding in a diplomatic manner about it. This cannot happen in any sensible country, that the rules of regulation that govern lawyers can be so flagrantly read by the Chief Law Officer of the country. And I am calling on the Nigerian Bar Association, beyond condemnation, beyond coming out to say he does not have power to do so. Let the NBA take responsibility for what has happened and go beyond press statements and go beyond condemnation to initiate the procedure under the law to ensure that Mr. Malami is sanctioned, is disciplined, until the policy of consequence in this country, until people are held accountable for such grave infractions, this country will remain the way it is. So, speaking for myself as a lawyer, as far as I'm concerned, the rules of professional conduct has not been amended. I will continue to affix my seal or my stamp, as it were, to all processes that I file in court, to all documents that I sign and frank as a lawyer. I do not recognize the legitimacy of these rules. I refuse to accord any other of respect to what is clearly a product of illegality and impunity. Let lawyers in this country stop paying lip service to the rule of law. The motto of the Nigerian Bar Association is supposed to be promoting the rule of law. So let us use Mr. Malami as a scapegoat. If a young lawyer had done what Mr. Malami has done, what Mr. Malami has been doing, that lawyer would have probably been denied the right to continue to be a lawyer in this country. So in conclusion, my position is clear and straightforward. that the Nigerian Bar Association should stop being a dog that can only bark but cannot bite. If we must restore the integrity of our profession, if our wig and gown must have any respect, any modicum of respect in this country, we should be able to hold people who violate our laws within the profession accountable. Otherwise, if Mr. Malami is not sanctioned, the Nigerian Bar Association will not have the moral authority to discipline any lawyer in this country for contravening the rules of professional conduct. The same rules that have been so flagrantly raped and violated. If the NBA does not discipline Mr. Malami, the NBA will not have any authority, will not have any modicum of right to sanction or discipline any lawyer in this country for professional misconduct. That is my position, and I will hold that position to any length.
We thank you very much, Barrister Effiong, for your succinct contribution. I'm asking, please, Mr. Kunle Edun, are you able now to? Oh yeah, he's still. Barrister Kunle Edun, please, are you still able? Are you not able to give us your contribution on this subject? You can unmute yourself, please. Mr. Kunle Edun, please, are you able now to unmute yourself? He's saying that there's heavy rain in Benin City where he's based at the moment. So well, we have had the contributions of the two major discussants. We have also invited Dr. Kayode Ajola to be with us tonight because I know that Dr. Ajola holds a contrary opinion to the two contributions we have had. So Dr. Ajola, are you able to let us know why you disagree with the submissions we have had tonight? Dr. Ajola. Can you unmute yourself? If not, I have a question to ask the...
Okay, no problem. Hello?
Yes, you are here. Go ahead.
Good evening. Hello, good evening.
Yeah, Dr. Ajola, we are hearing you.
Can you hear me?
Yes, we can hear you. Go ahead.
Yes, thank you very much.
I don't webinar, so I
can you see my interest today is to watch the comment of the colleagues, and I remember I gave you the reason why I wish to remain as such. It is always a pleasure to listen to one of our seniors, that is Afam Osigwe, and my brother and friend, Effiong. And I think that is exactly what I wanted to do today. I've already given that indication, and that is what it is. And the reason why I've done that...
Come to the middle now, come to the middle.
I don't think we need to go to that, but that is exactly what I really wanted to do today, because they delight to listen to two of them. And I'm even grateful that Mr. Kunle Edun is there. I think we need to do that. Though my position has been made known before hearing from some others' opinion. But as it is, I still really wish to remain as such. Thank you very much, and I wish everybody happy deliberations.
Okay, my question I thank you very much, Dr. Ajola, for, yes, you made that known to me. My question at this point will be to Dr. Rapulu Nduka, please. Apart from one of the arguments made by those who are against who supports the Attorney General is the legality of the payment for stamps by Nigerian lawyers, which the Attorney General has sought out to cure. So apart from the procedural irregularity, which is what the two discussants seem to disagree with, what about the substantive act which they have taken, what he set out to cure? What is your position on that as well? Can you educate our listeners on that point? Dr. Rapulu, Nduka, please, if you can unmute yourself. Is Nduka still with us? Hello? Wow. Can you unmute yourself, please? Hello? All right, if he's not hearing us, Inibehe, my brother, are you able to speak on that? Because that is...
Yes, please. Yes, please.
Yes.
Now, let us not confuse the issues. Like you rightly noted, there are arguments on procedural irregularity and legality of this purported amendment. But as a private legal practitioner, I have my own position on the appropriateness and the way and manner the stamp and seal policy is being implemented. Let me give you one example. It is totally inexcusable, and I say that with due respect to the leaders of the Nigerian Bar Association, for an expiration date to be put on the stamp. It is wrong. Why should I pay money to the NBA after I have paid my practicing fees and paid my branch dues? I now pay for the seal or the stamp and seal, which lawyers tend to use interchangeably now. And the NBA now says, no, that I can only use it up to 31st of March of the next year. Why should you have an expiration date? So lawyers have argued, and I am one of those lawyers, that is exploitative, that is wrong, that defeats the main reason for introduction of the stamp and seal. Because if the argument is that the seal is intended to checkmate quackery or fake lawyers in quotes, then putting an expiration date to it does not solve the problem. So when we have been making this agitation, but unfortunately the NBA, and when I say the NBA, I'm not speaking with particular reference to the current executive that just came in. I'm speaking of the NBA generally. The NBA unfortunately had paid lip service to this issue. The NBA has shut its ears to the cries of Nigerian lawyers that this policy of putting expiration date to the seal has to stop. Again, why should lawyers have to wait for weeks and months to be able to access it? So there are legitimate concerns that Nigerian lawyers have, which the NBA unfortunately has not been able to address. I understand that Mr. Kwata has proposed some reforms to this, and I hope that he will see it through. But beyond that argument, we should not for any reason use that as a basis or a justification to defend what is clearly indefensible. In a serious country, the Attorney General is insulated from political influence. The Attorney General represents the moral authority, the moral signature of a government. In a serious country, the Attorney General resigns in protest when laws are being flouted. But unfortunately in Nigeria, we have an Attorney General that publicly defends disobedience to court orders, an Attorney General under whose watch our courts are being desecrated, an Attorney General under whose watch a court was invaded, nobody has been sanctioned, and today the same Attorney General has been made a life bencher. While lawyers are protesting against the illegality, Mr. Malami has been defeated, has been elevated, sorry. Does it mean that we are going backward as a country? Does it mean that we have totally lost it? Does it mean that the legal profession has been captured? Does it mean that lawyers in this country do not have any modicum of self-respect? So I am very angry, I am very aggrieved. And I believe that my sentiment represents the sentiment of majority of lawyers in this country. So please, let us not make the argument that in 2007, the then Attorney General, Mr. Bayo Joy SN had violated the procedure in amending the rules. Thankfully, we have eminent lawyers like Professor Ernesto Juku and others who have come on record to state that the said 2007 rules was properly amended. So, even if it was not properly amended, supporting without considering for a second, are we going to study legality to defend illegality? I did not study law. I did not go to school to read law to begin to defend or begin to see this kind of thing. This is supposed to be a noble profession. When we were in the university, students from other faculties and departments used to be influenced of lawyers. Why? Because there was a certain level of prestige, sacredness that goes with the profession. Today, lawyers are being treated with scorn and derision. Why? Because we have abandoned the ethics of our profession. Why? Because we have allowed agents of impunity, agents of lawlessness to destroy and decimate the legal profession. Unfortunately, some of us can only talk. It appears that there is nothing that we can do. But we have to continue to talk. We have to continue to speak up. We have to continue to insist on the rule of law. If the NBA is tired of being a responsible organization, let NBA approach the CAC and surrender its certificate of incorporation. But as long as this motto of the NBA remains defending the rule of law, every lawyer in this country has an obligation to insist that the right thing should be done. And as I said, please let me re-emphasize it before I end this point. If what Mr. Malami has done does not attract severe disciplinary sanction, please let the Nigerian Bar Association not pretend that it can sit and discipline other lawyers in this country for misconduct. What Mr. Malami has done is professionally and officially unethical, improper, and condemnable. That is my position.
Inibehe, let me ask this question, which is what a lot of people are also confused about. The Honorable Attorney General said he carried out the amendment in the powers conferred on him by Section 12(4) of the Legal Practitioners Act 1990 as amended. And some lawyers I've spoken to have also said that in the exercise of such powers, the Attorney General's action is lawful, legal, and in the best interest of lawyers. So I'm still trying to find out, is your quarrel with this? Is his action procedurally wrong, or is it illegal? Because he cited a section of the law upon which he took the action.
Please, let us not be mistaken. That section you have referenced, Section 12, of the Legal Practitioners Act, is explicit. There is no ambiguity in that provision. That power is domiciled exclusively in the General Counsel of the Bar. Let me make an analogy. Imagine you wake up tomorrow to read in the press that Ahmed Lawan, the Senate President, has passed a bill without the session of the Senate or members of the Senate sitting and voting on it, simply because he's the Senate President. This is what Mr. Malami is telling us, that because I am the chairman of the General Counsel of the Bar, therefore I can exercise the power vested in the council. You don't need to be a law student. You don't need to read law in the university to know that that argument is non sequitur. It does not follow. The Attorney General is not the General Counsel of the Bar. He is only the chairman of the council. And that power is not vested in the chairman of the council. That power is not made to be exercised by the chairman on behalf of the council. That power is made to be exercised exclusively in the council. And the law is a special union is exclusive of terrorists, that the express mention of one thing is exclusion of others. Since the Enabling Act, the Extant Act, has exclusively mentioned the General Counsel of the Bar as the authority, the enacting authority, the implication is that no person other than that council can exercise that power. It is not delegable. the section 12 does not have a clause or a proviso that gives the council the power to delegate its responsibility to the Attorney General. The only thing that the Attorney General can do is to convene the meeting of the council. Today, all the members of the council who have spoken, including those who seem to have supported what Mr. Malami has done, have gone on public record to say that no such meeting ever held. Therefore, the council never met, and I support the position of the president of the Nigerian Bar Association that the rules of professional conduct has not been amended. The rules of professional conduct 2007 is extant. I am not aware of any amended version. So if there's any gazette, and you must have noticed that Mr. Malami has not even deemed it fit to publicly issue a statement in his name to admit to this amendment. What does that tell you? It tells you of an Attorney General who does not respect his professional colleagues, an Attorney General who has no regard for his profession, an Attorney General who has no respect for the integrity of the Nigerian Bar Association. The Attorney General is still a member of the NBA. So even if he's not required to consult with the NBA, are you saying that it is proper for this kind of decision to be taken without the knowledge or consultation of the NBA, without lawyers being given an opportunity to offer impute? That is even if we have the power to do this, which it does not have. So please, let us keep the argument straightforward. What he has done is flagrant illegality, and I will still want again that he has to be sanctioned for it.
All right, I would like Dr. Rapulu to answer this question if he's able to do so. If that were the case, why has the Nigerian Bar Association, why has the leadership of Nigerian Bar Association challenged the Attorney General in court? Are you able to tell us, please?
Okay, now I just, there are a number of things I may not be allowed to just say at the moment, because when you are in leadership, you adopt some style. And most of the times your style, it's not what you want everybody to, or your strategy rather, is not what you want everybody to actually know. Now, but if you had noticed, the president of the Nigerian Bar Association, first of all, made some moves or took some steps to engage the Attorney General on the said amendment. Now the good thing is that number one, we've engaged him. The engagement is still ongoing. We can also assure you and every lawyer that we will do every single thing within the ambit of the law. Now, but you know that when the first step, there were some points that Chief Ini was trying to make. The first step we've taken, there are some things that, you know, if I say right now, it may actually mean that I'm placing the cart before the horse. The good thing is that some members of the bar has actually taken some steps to sue or take out an action against the AG, and that's wonderful. There was a time some people asked, I was being asked whether we would go to court, but we prefer to take it one step at a time. And but the bottom line is that whatever steps within the ambit of the law that we need to take to make sure that the proper thing is done, we will take those steps. And that's it. But I just want to make one or two points before I just stop. I align myself with the submissions of Ini. And I just want to also say that I think that the argument or most of the times that I've engaged people on the issue of the stamp and seal, I noticed that the argument is that the NBA makes so much money out of the stamp, and therefore, and maybe most of the times it gives them an opportunity to embezzle those funds. But well, the good thing is that the stamp and seal didn't start with this administration. We are just about a month or two in office. Now, when we looked at the records that we have in NBA, we found out that the stamp or the payments for the stamp actually goes to the production. NBA doesn't actually make money from the stamp and seal. And that the figures show that they don't actually make money from that. And so when you hear people saying, oh, that's a wonderful thing, so that we remove that from NBA, that's a wrong notion. The good thing again is this. The president of the Nigerian Bar Association has also, when on his inauguration, had said that the NBA will now start footing that extra bill, and that people will now be getting, once you apply for the stamp and seal, you get at least 2 packs free. Then you can now, the next application will now be, you will now pay for it. So that's still a wonderful thing. So now, I don't want to just say this, but I think that whichever way it goes, it's actually a burden which we are ready to take upon ourselves, that extra burden. But then, so I want people to come off that belief that, oh, that's a wonderful thing. Oh, the NBA has been struck. Their money-making ventures removed from them. NBA does not really make money from the stamp and the seal. But then it's also, we should also look at it from the angle of the various advantages that it also brings. Now, for me, when practicing, this is 16 years now, one of the things that I noticed, or prior to the stamp and seal, is that people expect that maybe the courts would kind of call people out for not paying their practicing fees. But the reality on ground is that people, okay, I remember I was the PRO of my branch at the time this stamp and seal was introduced. Now I noticed that a lot of people who were not really paying their practicing fees, because those who actually end up paying their practicing fees are those who actually want to apply for maybe SAN or notary public or other applications within the profession. These are the people that actually pay their practicing fee. So most people do not pay for these things. And I can tell you that there's no judge who will leave, going into the merits of his case and start chasing around people. You do pay your practicing fee, so you will not have audience today in court and all this stuff. Most judges do not have the time for that. So it was the introduction of this stamp and seal that compelled people to start doing the right thing. So I think that, and it's unethical for a lawyer not to pay his bar practicing fee. So it is a wonderful innovation, and that has now, Ini talked about the expiration of or having an expiration date on the stamp and seal, or the stamp that we have. Well, I may not tell you categorically the rationale behind the having an expiration date there. Like I said before, it is an innovation that has been in place even before we came into, we are just new in this in the leadership of the NBA, so I can't tell you what has been going on before. But somehow I believe that it's actually a way of also helping people to pay their practicing fee every single year. Because if you know that your practicing fee is going to expire at the end of that's the NBA year, then by all means you take the next step by paying the next practicing fee. So I see that I don't think that there's anything wrong in the expiration, having an expiration on the stamp and seal. But then by all means, if majority of members of the bar believe that it's a wrong thing, that it is a terrible thing to have expiration on their stamp and seal, I believe that the leadership of the NBA currently will also have a look into that. Because I don't think that our main aim in trying to, in coming into a place of position right now is to start maybe making money or doing what every other person has been doing before. We want to cause a good change, a positive one. that will make everybody happy at the end of the whole day. I believe that a lot of expectations are, a lot of people expect so much from this current leadership, and we are not going to spend our time doing things that will end up making us not live up to expectation. So if it is part of the expectation, maybe we'll also have a look into that. But the bottom line is this: I believe that the current position on the stamp and seal is for the benefit of everybody. Thank you.
All right. At this point, we'll be happy to welcome questions from those who are viewing and listening to the discussion going on at this moment. If you have any question, please, now is the time. Or if you want to make any contribution to what has been said.
Yeah, I would like to make a contribution, Dan.
Okay, yeah, Maziafan, please, yes. Go ahead.
I'd like to make a comment with respect to a few things Inibehe Effiong said. First of all, he said the stamp is exploitative. That suggests that it is being done for a commercial motive. And I thought that this issue has been explained by NBA and the financial records published to show that NBA does not make a kobo from it. Now, he talked about the rationale for expiration of the stamp. Now, we need to understand that while the general belief out there is that the stamp expires, the stamp was introduced to fight quacks. That would not appear to be, that does not appear to be the stated reason in the Rules of Professional Conduct 2007. It was a requirement, and the Rule 10.2 particularly does not state that it is to fight quacks. While he may have achieved that as one of the consequences of his introduction, it is not, it is a regulatory issue. So that a document emanating from a lawyer on face value shows that it emanates from a lawyer. Now, he talked about the issue of expiration. If you look at Rule 10 of the Rules of Professional Conduct, it talks about what a lawyer who wants to be in practice needs to do. They need to have continuing professional development, meeting certain minimum points. If you look at Rule 12, it talks about MBA publishing an annual practicing list of those who are qualified to practice. If you look at Rule 9, it talks about a person not claiming to be a lawyer or presenting himself as a lawyer if he or she had not paid his annual practicing fee. If you read the entire rules 9, 10, 11, 12 together, it shows you that the stamp is part of the regulatory process in the profession. Yes, I concede that the MBA has not been serious about implementing the continuing professional development and publishing the annual practicing list. But these are things to show. It's just like a licensing like you do in the UK, where every year you renew your license. And that is why Rule 12 says that MBA should issue an annual practice certificate to any lawyer who has paid his practice fee. That part of the practicing license renewal package, maybe in due time we'll call it that, or the rules will be amended to specifically provide for that. Personally, I have my personal views about stamp. I do not think in this modern age and time, a lawyer should be identified, a legal document should be authenticated by a parchment called stamp and seal. But the majority of lawyers think it's a wonderful idea. And so my views pale into insignificance. Now, when we talk about renewal as if it is a very big deal, we should know that there's no way a lawyer or a doctor, a pharmacist, or any other professional can practice ad infinitum without any form of renewal of license. It doesn't happen in any part of the world. If it does, I would like to be shown where it happens. That's talking about the license. Even now that NBA has agreed to pay the stamps, in my thinking, I do not also that means that the expedition will go, because people seem to think it's because you're making profit, you want to force me to continue to. Now, let us even look at another side of it. A person can simply collect stamp that can last him or her for 5 years and refuse to renew his or her and stop paying practice fee and stop meeting with the requirements in Rule 11, seen as NBA has not implemented the issue about continued professional development points and also publishing an annual practicing list. Where does that leave us? Now, the other issue I want to talk about, Mr. Effiong also talked about that NBA should report the Attorney General of the Federation. If you read the Ganifa-Emi case, part of the issue in the Ganifa-Emi case is that NBA cannot be the accuser, the judge, and the prosecutor. NBA was the one accusing Ghani, was going to prosecute him. Inibehe Effiong, and indeed any other law, including myself, can rightly come under Rule 55(2) of the Rules of Professional Conduct, which in fact makes it almost a duty on any lawyer who knows that a person has violated the rules of professional conduct to report him to the appropriate authority. NBA performs regulatory role in the issue of discipline about lawyers. NBA is one of the bodies that receive petitions. It cannot write a petition to itself or to any of the other bodies that receive petition alongside it. Every lawyer, you don't need to be a victim of an act to lodge a complaint against a lawyer. So let us not think that until NBA does it, if people feel strongly about it, any person can. But I think rightly the argument is very simple, and which is why I agree with him. The General Counsel of the Bar is the only body that can amend the rules of professional conduct. It has not amended it. I ask myself, if me too, being a member of the General Counsel of the Bar, being one of the 20 members representing the NBA, if by tomorrow I can come up with something I call a gazette of an amendment of the rules of professional conduct, will people also say until that is set aside by a court, it remains the law? If any single member can just bring out a gazette and it becomes a law, I have my reservations about it, but like the publicity secretary has said, NBA is exploring some channels to resolve the issue, and I would want to sit back as a member of the association and allow the association to do it. When I saw that document flying around on the internet, my first instinct was that is a doctored document, is a Photoshop document, because there were no discussions, there were no meetings convened or held, or even suggestion that the rule will be amended. And that is why in the post I made on Facebook, I said that that document lacked credibility. And I still stand by that position because the Attorney General of the Federation has also not come out to acknowledge that document as one, which he proudly claims authorship of. So aside from the face of it, it appears to be a gazette made by the Attorney General, there has not been any external extraneous facts to suggest that it is authentic. So I would like to stop at this point. If there's only anything for me to also comment again, I would come in. Thank you so very much.
All right, well, thank you very much. We're happy to say that Kunle Edun is now with us in full body and spirit. So, Mr. Edun, are you able now to make that your...
Yes, thank you, Mr. Daniel. I'm sorry for coming a bit late. I'm also engaged in the Edo observation, the NBA observation team in the Edo election. And I think I agree substantially with what Alpha Bosigwe, my very good friend, and GS Emeritus have said. My other colleague in the National Secretariat, the National Board Secretary, has said much. I agree with them. The position still remains that with regards to the purported amendment of the ROPC, NBA still does not recognize such amendments. And it's also a fact that the Attorney General of the Federation has not even come out to confirm same. And if you recall very well, the first statement made by the NBA president, Mr. Olumide Akpata, is to the effect that members should disregard such purported amendments. I've been asked several times, okay, do we still use the stamp and say? And what I tell people is that, look, if NBA that you belong to as a member does not accept the fact that an amendment has been made, still believes that the stamp and say exists, and you still remain a member of NBA, then you have no other option than to continue using the stamp and seal. Because immediately, the moment you stop using the stamp and say, you are telling the NBA that you cease to be a member of the NBA, and there are always consequences for that. Particularly when it is likely that at the end of the day, the AGF or the office of the AGF may not be able to confirm that he actually issued that amendment. So it's better that lawyers continue using the stamp per se. Now, with regards to, I think I listened to my very good friend Nduka. He was trying to explain the reason why the stamps and say cannot be expired. There's this point that we also need to recognize. Of course, Afam has said the NBA does not make money from the stampers, and that is true. And that is why the past administration, and I believe that the present will continue that same pattern, we always publish financial reports of our financial transactions, our outflows and inflows. And it's expected that members would be reading such reports. But whether they do or they don't, I think they will be better positioned to answer that. Now, what am I saying? What about in a situation where a lawyer is suspended by way of directive of the FPDC, is suspended or is not struck off from the list, and the stamp and say has no expiration date? The lawyer, for example, practices in Warri and it disappears somehow and goes to Sokoto or Aba and start practicing. And he has enough stock of stamps and sales. He will continue using them.
That's just the truth. So the stamp per se, like what many of my friends have been saying, is also to check, apart from checking the fake lawyers, but also to check those lawyers whose names have been struck off or have been suspended by the LPDC. So with regards to rules 7, 8, 9, and 10 that were purportedly removed, deleted from the extant ROPC 2007, it is most unfortunate because those are critical provisions that actually seek to regulate the legal profession. And I want to believe that the NBA president is having a very, very positive and good engagement with the Honorable Attorney General of the Federation. And at the end of the day, this will just be a mere distraction that shouldn't have been at all. So apart from this, every other thing that Alpha Mosiba has said, and my very good friend Nduka, I'm okay with that.
We thank you very much. Let's call on, we have 5 minutes remaining for this discussion. Let's call on Uche Igwe, please, to make his comments or ask a question. Uche, please, are you able to unmute yourself?
Oh, yes. Thank you very much, Daniel. Yeah, I'm listening to the General Secretary Kunle and the Police Secretary Rap. I'm also listening to the former General Secretary, Now, I want to ask, is it not possible we borrow a leaf from other professional bodies like ICANN and the Surveillance Council, where they have a permanent metal seal with the practitioners, in our instance, the call number on your seal? Because I heard Madam Mosigwe argue that the seal is an attempt to regulate against quacks. I'm also aware that we have this license that they issued. I had the license for 2015, 2017 from the NBA. It's an expirable license. The seal, in my opinion, should be a permanent seal, like the Surveillance Council use, and I can use a permanent metal seal, that you use in your practice. Why the license issued by the NBA should be expirable for each year. Now, if you have any issues with the NBA, for instance, a letter that was the bad or the close, then it cannot be issued a license to practice for the next year. So I don't think, for me, it is a good practice for us to have the seal to be renewable every year. The NBA Press Secretary Rap has also tried to make the case that we don't make money from those sales. So what is the essence of paying every year for those sales when they're expirable and we don't make money from it? It is better we have a permanent seal at the Surveillance Council that bears the practitioner's name probably and the court to bar number permanent. Then the license now regulates your practice every year. If you pay your practice fee for the year and you comply with every regulation to practice for the year, the NBA issues a license to practice for that year. So I think we should look at the NBA as it should look into issuing permanent metal seals for practitioners, and the license regulates the practice for each practicing year. Thank you very much. That's my contribution.
Okay, we thank you very much. We will allow Barrister Kunle Edun and Rapulu to respond to this question. But Rapulu, please, how do you respond to what Uche Igwe has said?
Okay, I just want to say that I think that this argument, or with the speakers have actually answered this question. And the question is that one of the things that we always consider is this: how do we show on the face value, once you look at the document, for example, that this lawyer who appended the signature on this document is licensed to practice for the year? The stamp makes it very simple for you and very easy for you. Now, when you have, like Kunle said, and the former GS also said, when you have maybe for saying that when the only requirements you have is to just put the license. So does it mean now Uche was talking about having the license having an expiration date. Now, does it now mean that whenever you file a process, you now print out that time to request every lawyer that appears in court to present his practice license for that year? And so the stamp cures that effect, the fact. So once you just file a process, the court looks at it. The period you file the process, you are qualified to practice within that period. Now, I will tell you, I had a similar, something similar that happened some years back at the Supreme Court. Now, we had filed a process. That was still when the issue of the stamp and seal was still a little bit dicey. People were not too sure of the position of the court on that. So we filed this process without the stamp on the document. Now, the lawyer on the other side raised the issue of not having the stamp and seal on that process. So we put in a motion for the court to allow us to now affix our stamp on the document. Now, on the day we came to move the motion, the counsel now raised another objection that he is not sure that on the day or within the period that we filed that process, that I was qualified to practice within that period. And so what I just did was, I just told the court, let's not bother with this argument. Thank God I have the seal for that particular year. And I just affixed it, and that's cured the problem. Everybody just, it led everything to rest. Nobody talked about it again. Now, imagine if I didn't have the seal for that particular year when the document was signed. Naturally, any other person would have brought the seal for that year when the argument was ongoing. So he brought in another angle to it, and thank God I had the seal for that particular year there. So the bottom line is this: is a person qualified for that year, the stamp and seal gives you, it's a conclusive proof that the person is qualified to practice for that year. And that's why it is good that it still has the expiration date. Going into maybe removing that or abolishing that completely and allowing just this license to be the only proof. Our documents go far and wide. It goes to several places, and we don't know where it will get to. Do I start affixing my license to every process that I send? So I believe that that narrative or that argument has already been taken care of. The bottom line is that this stamp and seal helps us to regulate, helps us to know the people that are qualified to practice within that particular year. Thank you.
Mr. Kunle Edun, please. Do you still have some comments to make on what Uche said, and then use it to make your concluding remarks, please? Yes, go ahead, please. Quickly.
Yes, I don't think the NBA seal, this is my personal opinion, I don't think NBA seal, which is not, and I think issues of stamp and seal will likely be one of them. Not that they will be completely off the shelf, but better ways of regulating the issuance of stamp and seal and the usage, so that all the concerns raised by the participants so far will be addressed. I think those are possible ways that we are going to look into this stamp and seal, so that we can put all these issues to rest.
We thank you very much. Inibehe, please. Your concluding comments with regards to the topic we've had today. What do you expect from the NBA leadership and the Honorable Attorney General going forward on the topic we have discussed today? What do you expect, please?
Yes, quickly, 2 points. The first is that I restate my opposition, my vehement opposition to putting expiration date to the stamp. Now, the law today in Nigeria is that you can file process without the stamp. It does not render that process a nullity. It is only an irregularity that you can apply to a court. But we consider in the case of Nyesom Wike and Dakuku, that you can even make an oral application and bring out the stamp from your pocket and affix it in open court. So if I can file process without the stamp, and that process is not rendered incompetent or on grounds of absence of stamp, then this argument about expiration, as far as I'm concerned, with the greatest respect, does not fly. In any event, right of audience in Nigerian courts is not contingent on having a stamp. I do not need a stamp to appear before a court and announce appearance to represent somebody. I only require it when I'm franking or signing a document or a process. So this argument that you cannot practice law except you have the stamp is not correct, with due respect. The stamp only limits you when it comes to signing or franking documents. So in any event, if a lawyer's name is struck out from the role of legal practitioners, the legal practitioners have said that when that lawyer files an appeal, that discipline, act of discipline, is automatically stayed until that lawyer exhausts his right of appeal at the Supreme Court. And I know lawyers today whose name have been struck out, but they are still practicing law because they have filed an appeal. So to now put an expiration date of 1 year, because some lawyers may have lost their right of practice having been disciplined within that year, as far as I'm concerned, with the greatest respect, is not persuasive. I am begging with the NBA, please do not shut out our complaint. Pay attention to what lawyers are saying on this issue, because the reason why some lawyers are supporting the Attorney General because the NBA, unfortunately, has not been listening to us. Please listen to our concerns. In the United States, you do not require any stamp or seal. There are processes from the US court that I see, nothing like stamp and seal. All that you see is the name of the lawyer and the law firm and the signature. So let us have a digitalized way of determining which lawyer is licensed to practice law or not. Today, you can go on the website of the NBA and you can see any lawyer, any person who is a legal practitioner in Nigeria. So there has to be a way of resolving this issue that my learned seniors have raised without putting the expiration date. And finally, I restate my position that the NBA has to discipline Mr. Malami, whether it has to be on a petition by a member or by some other members who have submitted petition. Let the NBA guarantee that Mr. Malami, when the petition comes, will be made to face disciplinary action. Until this is done, the legal profession will continue to be a subject of ridicule. And it is unfortunate that that is what is happening today. That is why a policeman can slap a lawyer and nothing happens. That is why today, a man that drives a truck, petrol truck in Nigeria, is more respected than a lawyer. A member of Nupen that is assaulted by the police is more respected than a lawyer because there will be consequence. If a doctor is assaulted by a policeman, there will be consequence. But lawyers are being assaulted. Lawyers are being beaten up in police stations every day. Why? Because we lawyers have refused to respect ourselves.
My brother, we thank you very much. We thank you. Thank you. Dr. Nduka, please, what's your final word? Are you promising us that the Nigerian Bar Association will reach an amicable solution with the Honorable Attorney General of the Federation on this matter of the amendment of the rules of legal proceeding?
But like I said before, by all means, the leadership of the bar of the NBA is engaging, and by all means, the bottom line is to get to the bottom of the entire thing. Allow, if there will be an amendment to the RPC, then it has to be done in line with the law. NBA must be consulted. NBA has a part to play in any amendment that will be done. And I believe that, and I will pray that members of the NBA should please trust the leadership of the bar. By the time we are through, I believe that we will come to, everybody will be happy with the outcome of the steps that we are taking or that we would have taken by the end of the whole issue. Saying that at the end of the day, I believe that members of this noble profession will be happy with the steps that we have taken in ensuring that the right things are being done. INI has raised a lot of issues. We will keep on engaging, even members of the profession. The bottom line is that at the end of the whole day, we do what is right and what is good for the profession. So we'll go all out, take every step to make sure that the right things are being done. Thank you.
We thank you very much. Mr. Kunle, please. So we thank you very much. Despite your engagement at Benin City with the Edo State governorship election, you still created time to deal with us. Thank you very much, Mr. Edun. Dr. Nduka, we've been receiving press statements from you, updates on the observer mission to the governorship election. You still created at least 60 minutes to be with us. We thank you very much for being with us tonight. Inibehe Effiong, we thank you. Despite your busy schedule, you still remain more than you promised to stay up till the end, despite your busy engagement. We thank you very much.